Canadian Administrative Law/Foundations of Law. The Missing Constitutionalism of Canada v. Vavilov. Courts gave a new approach to choosing the standard of review in applications for judicial review and a revised approach for assessing the reasonableness of administrative decisions. 1. Overview of Vavilov, pointing to its key legal developments for judicial review and some of its implications for administrative law. 2. Two additional matters of constitutional structure that are at stake in Vavilov but which are insufficiently addressed. A. The consequences of an inconsistency between legislation and unwritten constitutional principles, and B. The significance of institutional design to understanding the role, relationships, and reform of public actors. 3. The place and status of the administrative state within the Canadian constitutional order, missed opportunity. Facts: Mr. Vavilov was born in Canada in 1994 to parents who, at the time and for many subsequent years, were believed to be Canadian citizens. As a Canadian-born child of Canadian parents, Mr. Vavilov was legally entitled to Canadian citizenship. 38 In 2010, it was discovered that Mr. Vavilov's parents had been living in Canada and then in the United States under false identities and had been, for Mr. Vavilov's whole life, operating as undercover agents for Russia. After his parents pled guilty to charges of espionage and were returned to Russia, Mr. Vavilov applied to renew his Canadian passport. His application was denied. He was told that, in addition to his Canadian birth certificate, he needed a certificate of citizenship in order to renew his passport. He applied for and received this certificate in 2013. The following year, it was cancelled. The registrar's decision was based on a report prepared by an analyst within Citizenship and Immigration Canada. The report included an interpretation of Section 3(2)(a) of the Citizenship Act. Section 3(2)(a) establishes an exception to the general rules of citizenship entitlement. It provides that the general rule that a person born in Canada is entitled to citizenship does not apply to a person if, at the time of his birth, neither of his parents was a citizen or lawfully admitted to Canada for permanent residence, and either of his parents was, a diplomatic or consular officer or other representative or employee in Canada of a foreign government. The report concluded that Section 3(2)(a) applies to employees of foreign governments even if those employees did not enjoy diplomatic and consular privileges. Accepting this interpretation and applying it to Mr. Vavilov's case, the registrar determined that Mr. Vavilov was not entitled to Canadian citizenship and thus, cancelled his certificate pursuant to Section 26(3) of the Citizenship Regulations. Mr. Vavilov applied for judicial review of the registrar's decision on grounds of procedural unfairness and substantive unreasonableness. Federal court dismissed. FCA found interpretation unreasonable and quashed the cancellation. The Minister of Citizenship and Immigration appealed to the Supreme Court. Holding, the Supreme Court unanimously agreed that the registrar's interpretation of the Citizenship Act was unreasonable and thus, the decision to cancel Mr. Vavilov's certificate of citizenship could not stand. A presumptive standard of reasonableness applied across all applications of judicial review. Courts should no longer speculate as to the legislature's specific rationale for establishing a particular administrative scheme or presume that an administrative actor's expertise justifies deference. Rather, the legislature's ultimate institutional design choice to delegate a power to an administrative body cuts across all other possible rationales on which the legislature may have been relying, whether expertise, efficiency, flexibility, accessibility, and so on. Presumption, rebuttable on two grounds. 1. Legislative intent. Reasonableness will be displaced when the legislature has indicated that it intends a different standard or set of standards to apply. Two kinds of situations: A. Where the legislature expressly prescribes the applicable standard of review, or B. Where the legislature provides that the decisions of a certain administrative actor can be appealed to a court. 2. The rule of law. Reasonableness will be displaced when the rule of law requires that the correctness standard apply. According to the majority, the rule of law requires that correctness apply for the review of certain categories of questions, c. constitutional questions, d. general questions of law of central importance to the legal system as a whole, and e. questions related to the jurisdictional boundaries between two or more administrative bodies. While not exhaustive, these failures are sufficient to establish unreasonableness if sufficiently central or significant to a decision. 1. A failure of rationality internal to the reasoning process, and a. read holistically, do not reveal a rational chain of analysis, reveal that the decision was based on an irrational chain of analysis, show that the conclusion reached cannot follow from the analysis undertaken, do not make it possible to understand the decision-maker's reasoning on a critical point, or exhibit clear logical fallacies, such as circular reasoning, false dilemmas, unfounded generalizations, or an absurd premise. 2. A failure of justification in light of the legal and factual constraints that bear on the decision. A. If it is not justified in relation to the constellation of law and facts that are relevant to the decision. The catalogue of relevant elements include, but are not limited to, the governing statutory scheme, other relevant statutory or common law, the principles of statutory interpretation, the evidence before the decision-maker and facts of which the decision-maker may take notice, the submissions of the parties, the past practices and decisions of the administrative body, and the potential impact of the decision on the individual to whom it applies. Author Glover Berger's opinion, in the Dunsmuir era of judicial review, deference to administrative decision-makers was justified at least in part because of features of the administrative actor involved or of the administrative state as a whole, features such as field of expertise, specialized contextual knowledge within a particular legislative sphere, and on-the-ground experience with the polycentric issues to be dealt with by the administrative agency. But after Vavilov, the presumption of deference is justified not because of any feature or set of features of an administrative actor but rather because of executive and legislative policy decisions to delegate some authority to a statutory body. Thus, the nature of the administrative decision-maker, and the special circumstances in which decision-makers operate, is irrelevant. The majority's reasoning in Vavilov points to an undeniable potential for conflict in the circumstances. The rule of law cannot tolerate a posture of deference on a federalism question. But the majority offers no guidance on the constitutional consequences of this conflict. It thus keeps this conflict between principle and prescription tucked within the administrative law sphere, without either drawing constitutional considerations into the administrative law analysis or projecting the issue into constitutional circles for consideration. Without merging the constitutional and administrative perspectives in this context, the majority reasoning in Vavilov signals that administrative law and the administrative state has its own constitutional law rather than participates in the development and elucidation of regular constitutional law. The majority had the chance to explain and justify this reasoning, limiting it if desired, and if possible. Instead, the reasons do not engage with the issue. The issue of the impact of unwritten principles on the constitutionality of legislation that affects administrative action is thus left to be resolved in Toronto City, where the issue is raised head-on. Additionally, the majority does not explain why the only design choices that are relevant to the new standard of review analysis are delegation, prescribed standards of review, and statutory appeal mechanisms. On the acontextual analysis that Vavilov demands, other design choices, and the interaction of the institutional features that flow from those choices, are irrelevant. In other words, it is irrelevant to determining whether a reviewing court owes deference to the decision-maker. This would be so even if it provided a strong indicator that deference should not be shown. When the majority lists the constraints and applies them to the facts in Vavilov, there is no consideration of the nature of the decision-maker or its unique and particular set of institutional features. This is so even though the majority retains the general principles from Dunsmuir, Cosaw, and Newfoundland nurses that the particular context of a decision constrains what will be reasonable for an administrative decision maker to decide in a given case, and that the review of an administrative decision can be divorced neither from the institutional context in which the decision was made nor from the history of the proceedings. These signals of the importance of the nature of an administrative decision maker, its design features, and its operational realities are not, for the most part, reflected in the list of constraints that the majority goes on to identify as relevant, i.e. the statutory and common law applicable to the decision maker, the principles of statutory interpretation, the evidence before the decision maker, the submissions of the parties, the potential impact of the decision on the individual to whom it applies. In this article, the author hopes these administrative constitutionalism issues would be further determined in more realistic ways in the very recent case Toronto v. Ontario summarized below. I personally find that the holdings of the majority are the exact opposite determination of what the author had hoped for. Administrative constitutionalism has occurred, but perhaps there is at least some clarity in the Berger case-based analysis that dictate grand levels of deference to administrations. However, the clear arguments set forth by the dissent, in which the reasoning of Irwin-Toy was considered more applicable than that of Berger, will hopefully allow the possibility of future reinterpretation of the analytical framework of administrative constitutionalism as provided by the majority in this case. Toronto, City, v. Ontario, Attorney General. 2021 SCC 34. The city and two groups of private individuals challenged the constitutionality of the act and applied for orders restoring the 47-ward structure. The application judge found that the act limited the municipal candidates' right to freedom of expression under S2(b) of the Charter and municipal voters' S2(b) right to effective representation. He held that these limits could not be justified under S1 of the Charter and set aside the impugned provisions of the Act. Ontario appealed and moved to stay the judgment pending appeal. The Court of Appeal granted the stay and, on October 22, 2018, the municipal election proceeded on the basis of the 25-ward structure created by the Act. The Court of Appeal later allowed the appeal, finding no limit on freedom of expression. The majority held that the city had advanced a positive rights claim, which was not properly grounded in S2(b) of the Charter, and concluded that the application judge had erred in finding that the Act substantially interfered with the candidate's freedom of expression and in finding that the right to effective representation applies to municipal elections and bears any influence over the S2(b) analysis. Holding, the majority also held that unwritten constitutional principles do not confer upon the judiciary power to invalidate legislation that does not otherwise infringe the Charter, nor do they limit provincial legislative authority over municipal institutions. Unwritten constitutional principles cannot be used as basis for invalidating legislation, nor can the unwritten constitutional principle of democracy be used to narrow provincial authority under S92(8) of the Constitution Act, 1867, or to read municipalities into S3 of the Charter. S2(b) may, in certain circumstances, impose positive obligations on the government to facilitate expression. Berger v. Alberta, 2007. 1. The claim should be grounded in freedom of expression, rather than in access to a particular statutory regime. 2. The claimant must demonstrate that lack of access to a statutory regime has the effect of a substantial interference with freedom of expression, or has the purpose of infringing freedom of expression, and 3. The government must be responsible for the inability to exercise the fundamental freedom. Dunmore v. Ontario, Attorney General, 2001. Majority, in the present case, the city has not established a limit on S2(b). The city's claim is a claim for access to a particular statutory platform, and is thus, in substance, a positive claim. The Berger framework therefore applies, and the city had to show that the Act radically frustrated the expression of election participants such that meaningful expression was effectively precluded. Many of the challengers who continued to campaign ultimately had successful campaigns, raising significant amounts of money and receiving significant numbers of votes. This would not have been possible had their S2B rights been so radically frustrated so as to effectively preclude meaningful expression. Some of the candidates' prior expression may have lost its relevance, but something more than diminished effectiveness is required under the Berger framework. In the context of a positive claim, only extreme government action that extinguishes the effectiveness of expression may rise to the level of a substantial interference with freedom of expression. Section 2(b) is not a guarantee of the effectiveness or continued relevance of a message, or that campaign materials otherwise retain their usefulness throughout the campaign. Furthermore, the unwritten constitutional principle of democracy cannot be used as a device for invalidating otherwise valid provincial legislation such as the impugned provisions of the Act. Unwritten principles are part of the law of the Constitution, in the sense that they form part of the context and backdrop to the Constitution's written terms. Their legal force lies in their representation of general principles within which the constitutional order operates and, therefore, by which the Constitution's written terms, its provisions, are to be given effect. In practical terms, unwritten constitutional principles may assist courts in only two distinct but related ways. First, they may be used in the interpretation of constitutional provisions. Where the constitutional text is not itself sufficiently definitive or comprehensive to furnish the answer to a constitutional question, a court may use unwritten constitutional principles as interpretive aids. Secondly, and relatedly, unwritten principles can be used to develop structural doctrines unstated in the written constitution per se, but necessary to the coherence of, and flowing by implication from, its architecture. Structural doctrines can fill gaps and address important questions on which the text of the Constitution is silent. Subject to the Charter, a province, under S. 92(8) of the Constitution Act, 1867, has absolute and unfettered legal power to legislate with respect to municipalities. This plenary jurisdiction is unrestricted by any constitutional principle. As for S3 of the Charter, it guarantees citizens the right to vote and run for office in provincial and federal elections, and includes a right to effective representation. The text of S3 makes clear, however, that it does not extend to municipal elections. Effective representation is not a principle of S2(b) of the Charter, nor can the concept be imported wholesale into S2(b). Section 3 and its requirement of effective representation also cannot be made relevant to the current case by using the democratic principle. Section 3 democratic rights were not extended to candidates or electors to municipal councils. The absence of municipalities in the constitutional text is not a gap to be addressed judicially, rather, it is a deliberate omission. The text of the Constitution makes clear that municipal institutions lack constitutional status, leaving no open question of constitutional interpretation to be addressed and, accordingly, no role to be played by the unwritten principles. Dissent. Rules, a two-part test for adjudicating freedom of expression claims. The first asks whether the activity is within the sphere of conduct protected by freedom of expression. If the activity conveys or attempts to convey a meaning, it has expressive content and prima facie falls within the scope of the guarantee. The second asks whether the government action, in purpose or effect, interfered with freedom of expression. Irwin Toy. Analysis: the appeal should be allowed and the application judge's declaration that the timing of the act unjustifiably infringed S2(b) of the Charter restored. Changing the municipal wards in the middle of an ongoing municipal election was unconstitutional. When a democratic election takes place in Canada, including a municipal election, freedom of expression protects the rights of candidates and voters to meaningfully express their views and engage in reciprocal political discourse on the path to voting day. That is at the core of political expression, which in turn is at the core of what is protected by S2(b) of the Charter. The right to disseminate and receive information connected with elections has long been recognized as integral to the democratic principles underlying freedom of expression, and as a result, has attracted robust protection. State interference with individual and collective political expression in the context of an election strikes at the heart of the democratic values that freedom of expression seeks to protect, including participation in social and political decision-making. The legal framework set out in Berger, which was designed to address under inclusive statutory regimes, only applies to claims placing an obligation on government to provide individuals with a particular platform for expression. Claims of government interference with expressive rights that attach to an electoral process are the kind of claims governed by the Irwin-Toye framework. In the present case, the S2b claim is about government interference with the expressive rights that attach to the electoral process, and it is precisely the kind of claim that is governed by the Irwin-Toye framework. Applying that framework, it is clear that the timing of the legislation, by interfering with political discourse in the middle of an election, violated S2b of the Charter. By radically redrawing electoral boundaries during an active election that was almost two-thirds complete, the legislation interfered with the rights of all participants in the electoral process to engage in meaningful reciprocal political discourse. The limitation on S2b rights in this case was the timing of the legislative changes. Ontario offered no explanation, let alone a pressing and substantial one, for why the changes were made in the middle of an ongoing election. In the absence of any evidence or explanation for the timing of the act, no pressing and substantial objective exists for this limitation, and it cannot, therefore, be justified in a free and democratic society. Unwritten constitutional principles have been held to be the lifeblood of the Constitution and the vital unstated assumptions upon which the text is based. They are not merely context or backdrop to the text. On the contrary, they are the Constitution's most basic normative commitments from which specific textual provisions derive. The specific written provisions are elaborations of the underlying, unwritten, and organizing principles found in the preamble to the Constitution Act, 1867. Constitutional text emanates from underlying principles, but it will not always be exhaustive of those principles. Unwritten constitutional principles not only give meaning and effect to constitutional text and inform the language chosen to articulate the specific right or freedom, they assist in developing an evolutionary understanding of the rights and freedoms guaranteed in the Constitution, which have long been described as a living tree capable of growth and expansion. Unwritten constitutional principles are a key part of what makes the tree grow. They are also substantive legal rules in their own right. Substantive legal rules in their own right. Substantive legal rules in their own right. Substantive.
Like this video, hit subscribe, hit that notification bell for more videos on Canadian law.